clarify, I'm not a doctor, but thank you for the additional title this afternoon. I would first of all like to thank you for the invitation, and also it's a pleasure to being able to contribute to your conference today, and also to visit this beautiful country. So the title of my talk today is BBMR-ERIC Perspective on Key European Biobank Materials. And in my talk, I will first of all briefly introduce BBMR-ERIC. I will tell you what are the trends in informed consent in Europe. I will speak about the EHDS European Health Data Space regulation and the changes to the secondary use of health data in Europe. I will mention the concept of trustworthy AI in medicine and biobanking in Europe. I will demonstrate then the complexity of the European environment on a case study of UNCAN Connect. And I will conclude with a few trends in participatory research in biobanks in Europe. And I will also like to mention at the end why the Declaration of Taipei, but also the Declaration of Helsinki, matters for BBMRI-ERIC. But I would like to first mention what is BBMRI. So we are a biobanking and biomolecular research infrastructure. We are a member state-based organization, and currently we have 26 members and observers across Europe, and also WHO, International Agency for the Research of Cancer, is also our observer. What you see here on the picture are orange dots. These orange dots are first of all, the squares. They are the national nodes that represents the biobanking communities in all of our member states in observers. And behind the national nodes, we have the biobanks. So our organization currently brings together around 500 biobanks at clinics and universities across the countries you see here, but also a few others, because we open our resources to those biobanks that provide data and samples in the area of rare diseases and COVID as well, even though they are not members and observers. And this network is also substantiated by a large number of experts. So we have ELSI experts across European countries. We have over 130 IT experts. We have over 300 QM experts that focus on biobanking, and our headquarters is in Graz in Austria. And we say that we're serving the society, academia, industry, also as a data infrastructure and as a technology infrastructure. Now, to understand how we operate, I will briefly speak about our federated access pipeline. So in the middle, we have the citizens, for of course the patients and the donors. And as they give their data to the local biobank then through the network of their national nodes feature or visualize what they have in their repositories in our directory and the federated platform. And the directory today features 7 million patients across 32 countries, while the federated platform, it is a more granular research tool, discovery tool, which features today 450 citizens across 10 European countries. And so when the user, so the researcher, asks for data or samples, we at BBMRI can negotiate this access and also support this access through different help desks and the training. Once there is an agreement on the delivery of the data and samples, and this needs to happen on the local level to be clear with the approval of the local committees and the local biobank, the researchers perform their research, and thereafter we ask them to return the data either to the original biobank, or if there is no space, to BBMRI, to the central repository. And our system is today very widely used in Europe. Only in 2024, we had over 10,000 users of our directory. We served close to 10,000 access requests, and together with our network, we published over 3,000 publications, and moreover, together with the outreach activities, we reached over 43 participants across biobanking events in Europe and beyond. So to continue, I would like to go to the informed consent in Europe. So the EU has a very strong legal background when it comes to the informed consent, and that is the General Data Protection Regulation, which is our comprehensive law, data privacy law, since 2018. And consent is one of its legal bases. It has to be freely given, specific, informed, and unambiguous, as according to Article 4. And in Europe, the consent is a cornerstone for respecting participants' autonomy, fostering trust, and legitimizing long-term storage, as well as the secondary use of our samples and data. In Europe, we currently see that there are really trends towards adaptive or broad consent, dynamic consent, but also increasingly digitalized consent models. But what we can say is that there are big differences amongst the European countries. Now, we have already heard about the positive outcomes of the broad research, of the broad consent for the researchers, but when it comes down to individual countries, we can see, for example, that in Spain, Finland, and France, the broad consent is fully legitimized and legislated and allowed. In Italy, for example, a broad consent is only allowed for research hospitals that are accredited with the Ministry of Health. And for every other participant research institution, they need to seek reconsent. And that is also in case, for example, in Poland and Germany, which makes it very specific about the needing to seek reconsent. Moving on, I would like to introduce European Health Data Space Regulation. Now, this is a new law in Europe, a European-wide law that is applicable in all member states directly, adopted last year, where the idea is really to open the data silos within the EU and make electronic health data available on a large scale. Here we speak about EHDS-1. This is the primary cross-border use of electronic health data for clinical use. But what we are really interested in here today is the EHDS-2, so the secondary cross-border use of electronic health data for research and policy making. Now, the EHDS introduces a very new governance system for Europe, and in the focus of this governance system will be the health data access bodies. These are the bodies that will be appointed by the government in each country, and they will be essentially issuing permits for access for the secondary use of health data. Now, the data holders are those entities that control the health data and will need to make it available. And in this category, we of course have also biobanks and other institutions that hold the data. And in principle, any natural or legal person will be able to apply for access under this new system in Europe. Now, what is really important and what is really a mindset change from the past is that all personal health data, and the EHDS regulation actually lists 70 categories of data. I mentioned some of them here: electronic health data records, registry data, clinical trial data, health data from biobanks. All of them are automatically included for research, innovation, and policy-making purposes unless you exercise the right to opt out. So this is now in Europe a fundamental change from the seeking consent from the patient, while instead we need to go to patients to exercise their right to opt out if they do not wish to be considered, if their data should not be considered for secondary use. So in view of this, at BBMRI, we have a stakeholder forum where we work with the patient organizations from about 14 European countries and also the European ones. We sat together and we put together a set of recommendations. How should we approach this opt-out that is a new mindset in Europe? First, we agree that we need to inform the patients that they actually have the right to opt out of the research. And this information, of course, needs to be hybrid, needs to be transparent, and needs to be very empowering communication towards the patient. We also think that the opt-out should be granular, flexible, and there should be dynamic control over the secondary use of data. We also think that should be a possibility to obtain a reconsent for the secondary use or anonymized data. And the opt-out system needs to be accessible, transparent, and multi-channeled. The focus needs to be on transparency and trust. And in the focus, of course, we need to have the patient and citizens' needs. And what is interesting that even though the EHDS is a European-wide law, the opt-out system and the implementation of the opt-out system is delegated to the national level, meaning that we could be facing with 27 different opt-out systems in Europe. So this is a potential hurdle that we will need to look at in Europe very carefully. Now I would like to move on to the trustworthy AI. In terms of the legal framework, we have first some soft law, European Commission guidelines for trustworthy AI from 2019, and the AI Act from 2024. Today I would like to focus on the guidelines for trustworthy AI. These guidelines put forward key requirements for AI systems that should meet to be deemed trustworthy, meaning they need to be lawful, ethical, and robust. And moreover, the European Commission suggests that there are 7 other requirements which we should be consistently looking at and evaluating and addressing throughout the AI system lifecycle. And these are, first of all, human agency and oversight, then technical robustness and safety, privacy and data governance, transparency, diversity, non-discrimination and fairness, societal and environmental well-being, and last but not least, accountability. And so if we are moving down from this overarching concept of trustworthy AI, we can zoom into what would be trustworthy AI in medicine and biobanking. And in this respect, we have done quite some work at BBMRI, where we believe that the trustworthy AI in medicine and biobanking should be, in particular, first of all, relational. So it is a relationship between AI systems, humans, and institutions. It should be human-centered, multi-stakeholder governance. So we should have continuous involvement of clinicians, patients, data contributions, and social science expertise across all stages. And last but not least, the AI needs to be contextually transparent. So it has to be meaningful and user-oriented information. And if we look from the side of the biobanks, what can we really do on the topic is to inform the debate about the trustworthiness of AI in the life sciences and health research. And this is at least what at BBMRI we try to do. We have had several publications on the topic, we have webinars on the topic, and we also have an entry on the knowledge base. So you're all very welcome to have a look there. Now, to demonstrate the complexity of the European environment, I would like to show you a flagship project on the European level. This is called Understanding Cancer and Can Connect project worth 30 million euro, which is aiming to establish a European platform for sharing and accessing cancer research data across the EU. So basically sharing diverse data types from omics, clinical, and imaging, for example, and also contributing these data types from across EU, of course, requires a very robust infrastructure behind. This system puts in place the Can Connect central node in the middle, which will provide a federated, open source, trusted environment. And this central node will be linking to a national node in every European country, to which there will be feeding of cancer data from all the hospital, biobanks, and universities. So like everything else in Europe, it's a little bit complex, but we are trying in this project to demonstrate the viability of this system, of this new infrastructure, through 6 different cancer user cases, which I listed on the side. So pediatric, lymphoid, pancreatic, ovarian, lung, and prostate. And what is important to mention is that in 4 of these use cases, we are looking into AI-driven models and tools. So the AI represents a reality of how health research is done also in Europe. And considering that we will be heavily concentrating on AI-driven models and tools, it is clear that within this project, we will need to look into the ethical considerations on data governance, compliance, and the definition what a robust operational framework can be. So in particularly, we need to look at a framework for data sharing and access policies and a trusted governance model. We need to address the challenges of AI applications, which needs to be evaluated against the trustworthiness aspect that I mentioned earlier. And we also need to uptake measures to ensure greater stakeholder engagement and transparency for the patients. So considering the important and ever-increasing role of the AI, at BBMRI we also believe it is important to increase the participatory research in biobanks. And here again, we have been working with the patient organizations in our stakeholder forum, and we have created a set of guidelines that puts out there the spectrum of patient and public participation, all the way going from inform, consult, involve, collaborate, and most powerful one, empower, where we really see that the patients and the public, they are involved in the decision-making process in the biobank governance structures. So this brings the benefits for the biobanks, of course, as well, because it increases our transparency and trust. It produces possibly better research quality and relevance. It also helps with the sustainability of the biobanks. And last but not least, you have different perspectives in the governance body. And what is also important that in Europe, we also have several projects that are aiming to identify and promote innovative stakeholder engagement with particular focus on the AI and also the European health data space and the changes that it's bringing. One of them is performance, which we are also coordinating at BBMRI. To conclude, I would like to mention why the Declaration of Taipei matters to BBMRI. So BBMRI, it's a European research infrastructure, membership-based, but of course we are collaborating also with countries outside of Europe, the third countries. And while the legislative network, the legislative ground for data privacy in Europe is the GDPR, very stringent one. Most of third countries do not have this, or they have very different national laws when it comes to data protection. So how do we ensure that if we have a member state joining from outside of Europe, that their biobanks concur to the minimal standards and the agreed international standards, is that we actually ask the government, when the government is joining the organization, to sign up saying, we therefore declare that the biobanks in our network that will be also joining your organization respect the principles enshrined in the Declaration of Taipei and Helsinki. So it's a really important document that we are now introducing also in the governmental communication on our side. And with this, I would like to thank you for your attention.
Thank you very much, Jana. You see, I didn't say Dr. Jana this time. Please come sit with us at the table. And before we take questions, we can move forward to our next speaker of this session. Our next speaker is Dr. Elodie Caboux. She is operational manager of the Biobank at the International Agency for Research on Cancer at the World Health Organization, IARC, WHO, in Lyon, France. She has a PhD in molecular biology from, pardon my French, École pratique des hautes études in Paris, France, with over 15 years experience in biobanking. She has expertise in biospecimen identification, collection, processing, management, and storage, as well as related and associated data collection and management. She provides technical and training support to IARC scientists and collaborators, and to members of the International Biobank and Cohort Building Network, BCNet, established and coordinated by IARC since 2010. Dr. Caboux is a faculty member of the French Master Program on Management in Biobanking at the Catholic University of Lyon. She has expanded her interest in high-quality sample procurement, ethical aspects relating to biobanking, and more recently, challenges of AI in biobanking. She is interested in pre-analytical issues related to biobanking and has been involved in the development of reference standards operating procedures. In relation to these topics of interest, she is part of the BBMRI Quality Management Working Group and Ethical, Legal, and Social Issues, ELSI, Help Desk. She has recently participated to European Pediatric Translational Research Infrastructure deliverables, specifically in shaping the EU-wide recommendations for the collection of pediatric samples. Let's welcome Dr. Elodie Caboux.
So thank you, Maiko, for the introduction. So I have the big task to do the last talk today, so I hope that I will keep you awake. During this talk, I'm on the side of the Biobank managers, so something a little bit different. And I would like to talk about more the international perspective. The topic here is to see and explain how governance of biospecimen and data is evolving, because we have a huge and significant evolution and transformation of biomedical research, so not only on technical aspects, but also ethical and regulatory aspects. So, as we all know, the biospecimen collection and the associated data collection is more and more growing, and this rely on patients, but also not only patients, but it could be also early participants, because today we talk a lot about patients, but it could be also healthy participants. So there are all these samples and data rely on that type of individuals, so patients or participants. And the objective of these biobanks and health databases is really to facilitate the health innovation and to improve the prevention, diagnosis, and treatment of disease. And in that way to support fundamental research. So we are all agree that now biobanks and health database are essential to health-related research, and especially the 5P medicines: predictive, preventive, personalized, participatory, and probable. So what has changed? So we talk a lot today. So there is a huge increase of digital health data with big also increase of collection of data on biospecimen for research and precision medicine. A big technological evolution regarding all AI tools and the genomics and multi-omics studies. But in parallel to this technological evolution, there is also an increase of public concern, because we talk a lot today also about privacy. What about the commercialization and the potential misuse of sample and data? So the new governance challenges are really the secondary or tertiary data use, the risk for re-identification, the data linkage, and the commercialization of sample and data. So it has been, this key notion has been mentioned in the previous session about this shift between static aspects of the research and the data set to a dynamic system and research ecosystem. So we are not anymore collecting data once for one purpose. We are collecting data, always collecting data, analyzing data, reanalyzing data, link data, and retrain data, etc., etc. So now we are not anymore in a static ecosystem, but really in a dynamic learning system. So we agree so that there is a huge evolution in terms of technologies, but can we consider that we all adapt our governance and our mechanisms at the same pace of change in all places of the world? And it's what I would like to highlight in the next slide to provide you some example. So, for example, let's focus a bit on what's happened regarding data and sample use regarding digital health and AI in Africa. So the current situation is that there is expansion of national and regional biobanks in countries like South Africa. We had an example just before, Kenya, Nigeria. But there are also some challenges like the problem of interoperability across the different health systems, some inadequate data governance, privacy or ethical frameworks. Also some issue regarding unequal access to technologies or infrastructure, especially in rural area. But also there is some inequity regarding how the biospecimen can be preserved in terms of quality. So we can say that Africa is really at a transformative stage regarding digital health and AI, but there is a real need to have a sustainable framework for data governance, ethical use, and also capacity building to ensure that there is an equity in terms of benefits. So here is a publication from 2025 that it's a review regarding the data protection framework in sub-Saharan Africa. So there is the background is that there is a fragmented regulatory framework, and the idea was to try to identify the data protection framework existing in sub-Saharan Africa. So the methodology was to do a literature review, including some keywords, of course, AI, Africa-based approach. So 56 article has been reviewed. And the result of this review is that the frameworks exist, but it's not not well implemented across the sub-Saharan Africa. So we have some countries like Kenya, Zambia, South Africa, Nigeria, and Uganda. In Uganda there is a very recent regulation regarding biobanking. All these countries show a mature system. And with the H3 Africa project, so for H3 for human, hereditary and health in Africa, so that was a project that started in 2012 and finished 3 years ago. This initiative largely supports the harmonization and the capacity building regarding biobanks and data protection in sub-Saharan Africa. However, the challenges are the fragmentation of the legislation, the limited enforcement, and the lack of interoperability. There is also a clear lack of data sharing agreement, and especially cross-border sharing, and also question of historical mistrust. So the way forward these challenges is to really not develop new law, because we know that there are some regulation and some framework already in place, but really to implement. And it makes echo to what we discussed just before with the example in South Africa, when the answer was to try to understand what happened to this problem regarding the transfer of data. And here it's really what I also would like to say is that we have the regulatory framework, but we really need to find a way to really implement the regulation to be sure that there are some controls at some point to avoid misuse of data. So the implementation of the framework, harmonization also of regulation, and also capacity building in terms of data management and bioethics. So the conclusion of this review was really that biobanking and data protection frameworks in sub-Saharan Africa are really emerging and progressing, but there is a need for initiative and really capacity building to have really strong support regarding research. And one initiative that's proposed by IARC regarding capacity building is the establishment of a network, so the BCNet, the Biobank Cohort Building Network that has been established in 2015, and Dr. Zizi Kozlakidis is the the coordinator of this network. So this network today is composed of 54 institutions in 25 different low and middle income countries. And we had the honor last year to have REBLAC, so the Latin American Caribbean network for biobanking, to be affiliated to BCNet. So this network has been created following situational analysis, and it came up from that analysis that LMIC are underrepresented in cancer research especially, and that they are less likely to provide sample for population-based research, and also less often engaging in building research infrastructure. So this network is really, the objective of this network is really to support biobanking and cohort building activities in LMIC. So it's part of what I just said before. We need to have capacity building in order to help the biobank in LMIC's country to gain into harmonization in terms of procedure, in terms of visibility, and to provide ongoing training. So among this BCNet initiative, we have done in 2021 a review regarding the regulatory framework that govern biobanking in LMIC countries that are member of the BCNet network. So we look at the different consent models. So we talk a lot about the consent model. So the specific consent, broad consent, or open or blanket consent. And the stakeholder perspective coming from this review is that the broad consent is more and more internationally accepted and adopted regarding appropriate safeguards. The LMIC concern is the history of exploitation, limited local research capacity, and the expectation from the participant to control and to receive feedbacks. So what came up from this review is that there is especially a majority of soft law, so guidelines, that are more flexible and updatable. For example, we have Zambia and Tanzania that restrict broad consent via law, and some other countries support the broad consent via some guidelines, like Nigeria, South Africa, Uganda, Gambia, and Brazil. The requirement is really to have a clear and strong ethical review and benefit sharing. And the challenge and the way forward is that the limitation or the absence of regulation is really a risk for the participants. There is also clear needs of legal framework and continuous public engagement. Again, a need to train the different stakeholders regarding ethics and biobanking. And there is more and more consensus going to the fact that broad consent associated to a good governance and all the ethical safeguard can lead to really an ethical and accessible biobanking research. So the second example that I would like to present is the one in Asia and the Pacific. So the current situation here again is that there are a lot of biobank, many initiatives like in Singapore, Japan, or Australia. There is a strong government support and also a lot of public and private partnership. But the challenges also here is the diversity in terms of regulatory framework and ethical standard across the countries. There are also some data privacy concerns. There are also aspects, as we just talked about Africa, we have different access capacity regarding technology between the rural area versus the urban area. And in terms of biospecimen collection, storage, quality, we have some challenges regarding the cost and the logistics. So globally, in Asia and Pacific, they are really leveraging digital health and AI, but there is a need for regional harmonization of regulation, data governance, and also a need to infrastructure investments. So here, similar to what I present for Sub-Saharan Africa, it's a review that has been done in Southeast Asia last year. So the current situation that came up from this review is that biobanking activity expand in that region. Especially the countries that are mentioned, Cambodia, Indonesia, Malaysia, etc. But the regulatory approaches vary widely. In Singapore, for example, there is a very comprehensive biobank-specific legislation. In other countries like Malaysia, Thailand, Indonesia, Vietnam, there are partial frameworks. And in some other countries, like Philippines, Cambodia, there is a fragmented or no biobank-specific framework. So many countries rely also on soft law and guidelines rather than dedicated biobanking law. So the key challenge in that part of the world is also the fact that there is no harmonization regarding the framework. There is also fragmentation limits regarding the cross-border sharing of sample and data. Very poor interoperability regarding public health emergency, and also concerns regarding benefit sharing and equity regarding access to the sample and to the data. So the way forward for Asia and Pacific is also to go for regional harmonization, to try to consolidate the overlapping that we can have between the different frameworks, and also to enable sample and data sharing, but with always the need to protect the individual interest and rights. So with AI, we have new ethical frontier and bias. So why? Because of the different factors that we have already mentioned, the whole genome sequencing and the identifiability that relates to that, the multi-omics aspects, the discrimination risk, the incidental findings, the return of results. So this needs to be included in an AI system, but we need to keep in mind that AI systems most of the time are trained predominantly on Western data sets, so that leads to underrepresentation of LMIC population. So the risk is to have the bias that we already mentioned in the previous session, health disparity, and some algorithmic injustice. So if we consider the LLM tool, that's had another layer of complexity because it's due to the probabilistic design of that tool, it can generate hallucinations, so that can lead to misinformation or a potential patient harm. So there is really an ethical challenge here, and it's difficult to impose the responsibility for the ethical responsibility for that tool to only one stakeholder. So all the stakeholders should be engaged in terms of responsibility. So the developers, the deployers, the end users, the publishing platform, or the regulators. So the one solution could be to have a dynamic ethical accountability framework with a continuous multi-stakeholder responsibility, and having to put in place some audits to be able to check all these steps in a continuous ongoing way. So the goal is really to maintain trust. It has been discussed a lot today, but it's really the idea is to maintain trust, to ensure patient safety, and to promote a responsible AI innovation. So the accountability is not one stakeholder responsibility. It's really something that should be collaborative. So it's this idea is recently published by Zius Kozlakidis and Michaela Mahehofer. So I invite you to look at this recent publication. So that's so the take-home message is that, as I mentioned before, we really need to shift from static to dynamic. So from can we collect and store data ethically to how can we be responsible stewards regarding complex, long-life AI analyzed data across border and generation. So the technological evolution or revolution is something global, but as I try to explain, there is a difference in terms of adaptation of this revolution depending on the settings and the country. So our responsibility is really to be sure that the evolution, the technical evolution, do not outpace the ethics. So that's my take-home message. Thank you.
Yes, thank you so much for your presentation. If you could please take your seat at the table. We'll start our question session. As I don't see any hands, I will start the conversation, maybe abusing my position as the moderator of this session, but it's for a justified reason. It's a segue from the discussion we were having in the previous session regarding material that or data that was raised by our colleague from South Africa that somehow ended up where it was not meant to be. And my question about this is, in a global collaboration scenario, how can we ensure that circulation of samples between countries with different levels of ethical rigor does not lead to data mining or exploitation of vulnerable population, and if the revised declaration of Taipei is sufficient to harmonize these disparities? Or do we need more aggressive cross-border auditing mechanisms? And this could be, for example, bringing from a structure perspective, infrastructure perspective, these countries to the same level, or helping them developing regulation internally that could bring everyone at the same level. And I refer to your statement that same pace of change in all places of the world, not the same pace, and we don't have the same starting points as well. And I would like to hear your thoughts about that.
Yeah, that's true. Yeah, exactly. It's clear that we are not evolving at the same pace regarding biobanking and data management and governance. But I mean, a way to secure, as I mentioned, there are a lot of available documents and regulation existing, but there is really a need to implement them. So as I said, in fact, it's not only the fact to produce document and that's it. Then we produce the document, but we need to be sure that the regulation is really applied. So we should find a way to have some checkpoints regarding the life cycle of a sample or data to be sure that all the user or the actors in this life cycle are really doing the things properly regarding the documentation and the laws and the regulation.
So from the European perspective, clearly each patient for now still need to consent very clearly that they agree with their samples or data being taken outside of the European Union as well. So in this sense, in Europe, we have quite a high protection. And I think if we are collaborating with third countries and engaging in global collaboration, what would help probably is also that we collaborate with institutions we have trust in, that we collaborate with researchers that come from trustworthy institutions, and usually having at least some collaborative framework in place would already help between these different institutions. And at the end of the day, I think we also need to look inside into our own integrity, whether or not we want to engage in an international collaboration with certain actors. I myself was faced with a private company coming from one of the African countries that was offering us databases of about 2 million patients from Africa, working on behalf of collecting this on behalf of the government for the personalized medicine. And when we asked what was the consent given, what is the data protection behind, they were unable to answer those questions. So at that point, we of course stopped this collaboration. But there is, of course, also on ourselves to make that critical judgment at the moment and see if things are not going in the right direction to stop the chain.
Thank you so much. We have one question from the gentleman at the back.
Yes, Dr. Tonini told us that in case of extra-European cooperations, you check whether the other countries work at least according to the standards of DOH and DOT. And Dr. Caboux, you gave us a lot of information about the regions in the world and the different levels of regulations. Do the Declaration of Helsinki and the Declaration of Taipei play a role in these negotiations or in these cooperations?
Yeah, I think that in all the regulatory documentation available in different parts of the world, these declarations, so DOH and DOT, are the principle are all included in the documentation. Yes, in the framework. Yeah.
Any more questions from the audience? And so while we gather more questions from the audience, I would like to, actually it's a note I took during your presentation, and probably most people in this room know that recently the Mercosur and the European Union, well, they were very close to an agreement. And my question is, how could this facilitate the integration of biobanks internationally, maybe in the terms of BBMRI? How is this something that would facilitate, or we still have a lot of work to do in this sense? And in the event of an agreement not being reached, would that still be possible?
So I'm not an expert on the Mercosur agreement, but per se, this is a very different type of agreement that deals with the transfer of goods and services, to my knowledge. So if we want to facilitate collaboration in the biobanking field between the European and South American, one way to do this is, of course, through us as BBMRI, as an intergovernmental organization. And we are happy to look at the countries who are willing to join the organization, and with that, they become an equal partner amongst also all the other, our member states, to discuss these topics that we are discussing here today between all the national node directors, and further the implementation of quality management of the IT ecosystems that are needed for the data sharing in Europe, but also beyond. So from my perspective, collaboration between the biobanks in this region and the European biobanks can already happen. It should not be an obstacle for that.
Thank you. Any comments on that? Any more questions from the audience? I think we still have some time for discussion. So, well, at the risk of monopolizing the discussion, if we don't have anything from the audience. Oh, we do. Thank you so much, sir.
I was thinking between the retrospective and prospective studies involving biospecimens, if there's difference doing the ethical aspect issues on that. If you have a specimen is already reserved and you're going back, or not studying a new study, would that be any difference for these?
So in Europe, prospective sampling, this is something where we are at the start of. So it's not yet fully running, I would say, but we really see the need for this in the future, and in particularly because we feel that we have a very good network to also help industry and serve the industrial users with the health data that we have. And this is another topic that is very high on the agenda in Europe. So how do we convince the patient that they should in principle, or that there should not be harm if they would allow or give consent also for not only academic use of their samples, academic research, but also research that is done by industry. And so this is a topic that we are looking at the moment, what exactly this means ethically. So in Europe, there is the same and only one legal basis for this at the moment, and this is the GDPR. So this does not change, I would say, whether it is retrospective or prospective, from my knowledge. The law itself, the privacy requirements need to be abided in both cases.
Anyone else? So, as we are approaching the end, I still have one more question, and it's regarding the AI use with biobanks, because that's a hot topic today, of course. And you talk about a dynamic accountability framework in your presentation. My question is, if biobanks are the fuel for training in AI in healthcare, what is the level of ethical responsibility that the biobanks have for the integrity and cleaning of the data? And how can this accountability framework be applied to ensure that error or bias in the original sample is not amplified by an AI algorithm, potentially causing patient harm in the future? What is the responsibility of every stakeholder